All right. So we're talking about trusts, okay? All trusts on level, but we're talking about private trusts. So the good thing is that I've actually set these trusts up for people that need to do it, like, you know, on a lower sort of like budget, but still have the maximum security. So, you know, we've obviously got great support for doing our trusts, but it's just one of those things. Not everyone's on the same levels of income, etc. So we were told, and you get told all the time by those that think they are better than us, right? Own nothing and control everything. You must have heard them saying that, right? These people, they want to call themselves elites, but I never call them that because they're certainly not that. But the Rockefellers, for one, and they tell you, like, you own nothing but control everything. And the great thing is, if you have got like all of like property or whatever it is like that's in your control, but it's not in your name, right? There's nothing that people can do to harm you with that item of property. For example, like 2 calls that I've had there this week, and people have turned up and clamped the car because they're saying there's an alleged debt on something else. And they've clamped the car, saying that they won't release the car until this debt is settled. Now, if you have a vehicle of any type whatsoever, and you put that in a private trust, which is like our vehicles are all in private trusts. Okay, well, I've only got one now. Somebody just drove into the bloody thing, right? But if you're in a private trust on your, now everyone's different. I have registered mine, all right? Well, I've explained why I do that for myself. But on there, it's registered as the trustee. So the owner is blah, 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 private trust, right? The name is trustee. So it's not my name. So when anyone turns up, if anyone ever turned up and says, right, we're going to go and clamp, they can't clamp that because it doesn't belong to the person, you know, I'm talking about person, the capitalized name, and that's all they're looking for, doesn't belong. So they can't do anything with it. This is what we're talking about. This is the protection that we need. So we're talking about building our castle, right? Which is why I'm setting up a community trust where you're going to be able to put your private trusts into a community trust. It's all about protection. So you're going to build your castle. Okay, that's your protective castle. Your assets are going to go inside, which is you. So first thing is you're going to find a hill. You're not going to go and build your castle at the bottom of it. You're going to build it on the top. Okay, to protect yourself. Now, once you get up and you've got like the best view and you can see everything, and you're higher than looking down on everyone else. So if they're invading you, you can throw stones down at them. Then you dig a big moat around it, big waterways, right? So they can't easily get through. And then once you've dug your moat, then you build your castle wall, right? And then they've got to get over that. And then inside you build a big tower. That's kind of what it's like, all right? So that's what we're doing, but with trusts. So we're going to own nothing. This is our protection, but we're going to control it, okay? All right? We're just going to do what they do. We're just going to copy them. We're going to do what they've been telling us to do. Okay? So this is what this is all about. And then what we'll do is we'll go through the documents and we'll hopefully help you to set it up. And everything that I've done is editable a word? I don't know. But you're able to edit it and put your details in, okay? We're talking about, it is a law and a real law. It's not acts and statutes or any of that nonsense. It's trust law or equity law. You'll hear the two, or trust and equity. All right. Now, the law of equity, that's what we'll really stick with, equity rather than trust. It trumps everything. All right. I don't know if you ever used to play that when you were a kid, like trump cards, who had the best engine and all that. It will smash common law. All right. Commercial law, contract law, or statutory legislation. Statutory legislation has got no chance when it comes down to equity law. Okay, so that's why we're actually going to be well above what they're trying to harm you with when you're talking about anything property-wise, bill-wise, claims-wise, because we're going to use equity in trust, right? You've already put yourself so above that. That makes sense? Okay. A trust is a 3-party thing. You'll see this quite a lot. I've seen this in loads of different things. Okay, so you've got 3 points on there, and there's 3 parts to, or 3 entities, let's call them entities to a trust. So you have the settlor or settlor, whatever, posh. Now in the USA, they'll call it a grantor. This is the creator. This is whoever actually created the trust. So if I'm going to create a trust, I want to put my items, property, something that's proper to I'm going to put it in the trust. I am going to be the creator. So what I need though is I need a beneficiary. The beneficiary is going to get the use of the items that we put in the trust, even if it's later on, all right, but they will get the beneficial use of the items in the trust. Then we have a trustee, and the trustee is the entity that looks after the items that go into the trust. So let's make it really, really simple. Right, so this is my property, right? We have the black marker pen for right on here. So I want this to go in a trust so no one else can actually harm the property of it's mine. Okay, so what I'm going to do is I'm going to go and give it to a trustee, right? Now I'm on my own. I can give it to my dog maybe, right? But I'm going to give it to a trustee and they have to look after it. So what I'm going to do is I give it to them and I put it over there in that trust and I give them a set of rules. And those rules are what they have to do to look after that. And they have to follow it in equity law, right? That's really, really strong. They have to do everything that I've said they must do before they release it to the beneficiary. Now, the beneficiary can be me or it can be a different person or party as well, okay? A different entity. So when we're doing it, and because we're doing the trust, all right, it's a three-way deal, but we're going to be dealing with, it is a person in the sense that hopefully you understand what a person is now, but we're also dealing with a man and woman, okay, which are all entities, but we do deal with a person, and we'll explain why while we'll go through it, okay? It's for that added protection. It's what this is for. Now, hopefully that you all know we're talking about everything is available for you now. You can actually take this and create it now. Obviously, if you need help doing it, then just, you know, give me an email and we'll help you. But this is the basics and the basis of a trust. This has been around for hundreds of years, and this is used very efficiently by those that want to rule. But they want the rules to be our rules and rule us, and they don't want to do what they like, what we're supposed to do. So they put themselves above by that, right? When they're passing these massive like country estates that have got hundreds of miles of property, land, as well as these massive mansions and castles, they pass them on via a trust, and they don't pay any taxes or anything like that on that property because they're all in private trusts. Okay, so that's all we're going to do. We're going to use them the same as they're teaching us to do them. All right, so what we just said, the settlor creates the trust. All right, the settlor settles property into the trust. So they're going to put property, they're going to put items into the trust. Property, when you're talking about trust, you'll hear it called a res. Okay, a res. That's what they actually call that property. So what is property? It is proper to I. So whatever I, a man, under the creator, under God, if you want to call it God or Allah or whatever, but under the creator, what is proper to I, what is mine? So whatever is owned by I and is proper to I. But when we're talking about putting that into a private trust, if you have a son and daughter, that is your property. And you can put your property, your son and daughter, into a private trust. Your body is your property. It's proper to I. No one else is allowed to touch it unless I allow them to. Okay, so that is your property. You can put that into a private trust. This has been proven. Okay, fingerprints, they are your property. So if you want to put your fingerprints into a private trust, you can put your fingerprints into a private trust. Your eye scans, okay, you all know what I'm talking about. Your DNA, your own blood, and every other, like, you know, liquid item that you can imagine can be put into a private trust because it is your property. That is true. Okay. And that can be put into a private trust, property proper to I. I check reference books, I go through reference books, and I study courses as well. But just if you want, okay, you've got 2 books that I do study. Equity and Trusts by a guy called Alistair Hudson. Not bedtime reading. Okay, so here, I don't know if that's light enough. All right, there we've got that book there that I'm talking about. You can see, you know, it's not something you want to go and sit down and curl up with, getting with your little pillow, getting ready to go to bed. And also the next one that's on the board, you can see there, it's Gilbert's Law Summaries. Now there's the name on here, it says Trusts, Edward C. Halbach. That's Halbach. Just in case you need the name, I don't know, but and that's Edward C. Halbach or Halbach. I don't know how to say it, but probably Halbach Jr. And that's really good. And you cross-reference them. Okay, you cross-reference them. So if anything comes up, you can use them to cross-reference and see. It's like, you know, everything that you can imagine that you need to know on a private trust or a trust, statutory trust as well. Not that we will be using them, but it does help to know those things. Okay, so I don't know, Google them, go on to Amazon. So equity, it could be called fairness. Okay, so equity, right? It's a separate body of law which has grown and developed. I know this is terrible writing, I know that. Grown and developed in the Chancery Court. Hopefully you'll have heard of the Chancery Court. A lot of man and woman go and try and gain their remedy, they call it, remedy, by applying and declaring themselves as a living man in Chancery Court in equity, by doing the lawful notice and demand that we hopefully have done, and then declaring yourself alive. And this is the Setter KV Trust. Everything is a trust, and this is how we're actually developing things through a trust. But equity could be called fairness, right? And it's all done in the Chancery Court. Okay, but where did this all come from though? Okay, it just didn't appear. So the Chancery Court, it's a very special place. In 1154, we had King Henry II. Now, when he became king, and what they had is, like, imagine all of England, and we're talking England here. Every single land that had been given, I can't remember what it was his great granddad or whatever, like William, who went and like killed everyone and then gave all of the French the lands around England. Okay, so the all of these lords or earls or whatever it is had their own rules, regulations, and laws. Call them what you will. So if, like, in say it's just Northumberland, for instance, and you had, it was divided into 3 places, and you had the de Laval family, which is French. They actually, the house is only about a mile from me. They actually came over with William, right, in his fleet. Now they've got a massive big mansion up there, and they owned most of the land here, and they had their sets of rules. But if you crossed the border and went further north, you'd have hit into a different family, right, which now I think is the Hastings, okay, like the Battle of Hastings, but I don't know if it's an intention. And they would have their rules, and everyone was always crossing borders and everything like that when they were moving, and they all had different rules. So what Henry did, King Henry II, he traveled England, and he went to, look, I'm going to make the law common to all. Law common to all, so that everyone had the same rules, so everyone had the same laws. So you weren't going to be doing something in one area and actually it was against the law in another area, and vice versa. This is where the term comes from. Okay, there's no such thing as, oh, I live under common law and I've got an umbrella and I can do whatever I want. That's just like craziness, right? This is where common law comes from. Okay, so, but the thing is, right, what he would do, he would actually travel the country and he would hear cases. So like you had a complaint against your neighbor, or you had a complaint against a lord, then they would hold their court and you would attend, and it would be the king. So you would see the king and you would state your case, and he stole this sheep from me and blah, blah, blah. Okay. Now, eventually, can you imagine how, like, you know, like the king's traveling around thinking, this is far too big and it's like far too busy. So he actually got help to run the courts. And it was the chancellor. He had a chancellor. So the chancellor started to help him run the courts. Now, eventually, it ended up saying the king, obviously, look, I'm too important for this. So they gave it all to the chancellor. So then the chancellor, or the Lord Chancellor, as it was called then, now, and still is called the Lord Chancellor, got to hear all of the cases so that Henry could bugger off and do whatever he wanted again. Okay? He got pretty sick of it pretty quick. Eventually, he did stop traveling around the country. Now, I mean the Chancellor and the King, okay? And it became the court of the Chancellor. So the Chancellor still runs the court today, and it's called the Chancery Court. And that's in London, in the city of London, okay? We're coming on to a trust. So I've just showed you with my pen on there. So a trust is a device, right? In our case, a person, and it will be, and I'll explain what I mean by that. They will hold property for the benefit of someone else, a man or a woman. In our case, again, I will explain that. All right. So what we're going to do is we're actually going to have a person, and it will be a person, and they are going to hold all of the property items, etc., for us, which we're going to be acting as a man and woman. All right. And it has to be very specific to be private. You have to be in the private, and you have to set it up as a private trust, and you have to use specific language if you want it to stand up if you were ever challenged. This is what it's all about, how to protect yourself when you're challenged. So if they turn up and turn around, well, it's not a private trust, or it's not a trust, or anything like that. It has to be set up. So if you look through the deed, the way that it's language, the way that the words are used, it might look weird and confusing, but it has to be set up in that language as a law under the creator. Okay. All right. Which is, so on a trust, there has to be three certainties. This is equity law. This is how it has to be. There has to be an intention. All right. So the settler must express a trust or say it. You've literally got to state the fact that you want to create a trust. I create a trust. Creates a trust. But what we want, though, on our case, because we're going to look after ourselves and try to look after our property, be it like, you know, our homes, our cars, our sons and daughters, our bodies, our fingerprints, we're going to put specific dates on it, and I'm going to explain how to do that so that you've got paperwork, backup, proof of how, when, and why it was created. Okay? So the settlor, who settles property into it, who creates the trust. I haven't put number 3 in. Look. All right. So there also has to be an object. Okay. So you have to have an object to actually put in. So obviously you're going to, where's the pen? On there. That's right. So you've got your settler, which is going to express a trust and tell them that they want to do it. And then you've got like the object that they're going to put in. We said it was a pen, but obviously you're going to have your property and everything else like onto there. So you're going to be telling them what property that you want. So what I'm going to do soon is I'm going to actually put up the documents that we have onto there. Okay. All right. So, and then we'll put the third one in. Okay, which is your intentions with the property. Now, this is my way of saying this. I've actually got a very good description that's from one of these books, okay, which will explain it better, and I'll write that up far better than what I could actually do it for. Okay, so that is the basics of it, the very, very bone basics. So what I'm going to do is I'm going to share the screen for the documents. I don't know if, like, you know, some of you have done it already. If you haven't, oh, hang on, I've got one question here. So what is that? Anne Marie, I think it says. Unmute. Yeah, Marie. Yeah. Hello.
How are you? I just wanted to ask one question just on your comment that I am in the private, however, my partner is not. So I should set up this trust by myself. Is that kind of in a nutshell?
Right. Okay. So, and is he going in the private?
I think he's taking a little bit more. He kind of is the type of gentleman who wants to look into it himself. So he hasn't had time because he's quite busy at work. So I think he will, but he's not at the moment. And I want to set up the trust like yesterday.
Okay. So the beneficiary. Okay. Yeah. Right. So that actually can be anyone. This one, the trustee, when we do it, is going to be the person.
Yeah.
Not private.
Yeah.
Right. This has to be private. You want to be private. That can be anybody. That can be a person.
Okay.
It's not a massive problem. Okay.
Okay.
And then obviously it gives you time to convince him.
Yeah.
But, you know, at the end of the day, if you imagine how you set it up. So if it was, we'll not go into personal details, but if it's property, then, you know, the at the top on the settlor law, that could actually be both private or not.
Mm-hmm.
So if it's a joint properties, for instance, doesn't matter, it's putting it into there. That makes sense?
Yes, that makes sense.
All right.
So if it's property, it wouldn't matter. If it was anything else, it would.
Well, no, whatever, property or sons and daughters or anything. Well, it's property. Any see what? That's a mistake of mine. Anything is property.
Yeah.
Okay. Everybody always thinks of a house, but it's not. It's like literally, like, you know, that is property. You are property. All right. So, like, you know, when you're in a relationship, literally, you're property of each other. So, you know, whatever you're going to put in, as long as you're going to do it, it doesn't matter how it's set up. What you need is the trustee has to be separate from you.
Yeah, that makes sense.
So we're going to set the trustee up as a person. But what you can't have is the trustee be the beneficiary.
Okay. Yeah.
So you might have to, but there's ways to fiddle with it. But as long as the trustee and the beneficiary are different, all right, it can be the same for a very short period of time when I've seen statutory trusts swap from places, but it's very specific laws that have to follow as it swaps. The trustee can be a beneficiary for a very short period of time. But on our case, because it has to be a private trust, you want it completely separate as much as possible.
Okay, makes sense.
Right? But I mean, you know, literally, you, in your case, if there was a partner involved, the trustee could be your legal fiction.
Yes.
Only your legal fiction.
Yes.
And then both of you could be the beneficiary.
Yes.
Yeah. So it's not a problem.
Yeah.
There's ways of going around it.
So one question off that then, just I was considering going to open up a bank account for the trust. So should I keep the bank account in my name?
So the thing is with the bank account, it doesn't have to be set up as like, you know, like a blah, blah, blah trust account, because that has to be very specific on there. But what you can, as long as that trust can be proven to be, as long as that bank account can be proven to never be used for anything else except trust business.
Yes.
Then it doesn't matter.
And it's fine. Okay.
Yeah. But you can't have a trust account. Literally, I mean, you can't have a bank account and go and like spend all your shopping on it and then expect them to understand or comprehend that is a trust account. Only trust money can go in. Only trust money can come out. Only transactions can be done for the trust for there. You can't go and buy, you know, like your weekly shopping with it or anything like that. It's only trust business. As long as it's there, it doesn't matter whose name it's in.
Okay. Thank you so much.
No problem. No problem. All right. So we've got. Hi. You all right?
Yeah, not too bad. Will you be explaining how to express a trust in the sense of do we have to inform somebody?
Yeah, going to do it right now.
Lovely.
When you say the settler has to be in the private, does this mean we have to already have become a secured party creditor and a private company?
Not a private company. No. Being in the private means that you have like at least started the process of going on the lawful notice and demand.
Mm-hmm.
Okay, you don't even have to be a secured party creditor, that because that is only specific to certain areas that we want to attack, right? So you can actually do that with a different thing, you know, like if you're going to try and do a 1099, then you definitely want to be on a secured party creditor, i.e. have the UCC1, all right? But if you're not doing that, then you can not even do the UCC1 filing. You can just leave it completely. But you want to be in the private, i.e. filling in the lawful notice demand with, which is now I've combined a few of the documents together. So there's not 6 or 7 documents, there's only 3, but obviously the lawful notice demand is much bigger. Makes no difference, okay? On the security agreement, the security agreement is tying in with the lawful notice and demand, and it is using your property I to put into a security agreement, as well as tied it to the private trust. Okay, so if we go to the top here, security agreement number, hopefully you'll all understand what that is now. It's the same, at least the kind of same reference number, only this is obviously Fred Henry Smith, FSHS 01/10/2021, so that's the date it was. SA for security agreement held in private trust named Fred Henry, private trust number, blah, blah, blah. Okay, held in perpetuity and expressed in equity, which it will be. All right, so some of the, hang on, I'm going to move this over to there. All right, so some of the security agreement will look similar to what you have done, but it's really coming down to like the collateral here. So if you look on the right hand side, obviously all the red bits is where you're going to have to put your details into it. Okay, so it's listing here literally. Now you can go over anything and everything that you want to include into this, and it all goes into a security agreement. Now, how would I express this? Back in the olden day, let's call it that, then they would put everything into a security agreement and expect it to be held and expect the governments per se to hold all of this as accountable to them and not touch any of the items put in, i.e. as if it was in trust. But if you look here now, obviously I'm not going to go over every single item. You know, you can go over that, but if you look at it, okay, if you look, so like on the left-hand side, you look, all collateral includes all receipts and proof of purchase, registrations, products, goods, services, proof of clear title and ownership. Collateral includes all crops, the host that the crops are harvested from, and all harvested and unharvested crops. So you're trying to cover literally every single aspect that you possibly could. And now taking it down a little bit more, and it's telling you about like any rents that paid and anything like that. And we're always quoting the private trust number. Now you make that private trust number. So we have Smith & Smith private trust 31102. So that's the 31st of the 10th, 21 PT, meaning private trust, held in perpetuity and expressed in equity. So if it was me, I would put like, and it's just let's say Peter Wilson private trust. That's how I would write that in, all small case, by the way. And then put today's date. So it would be like Peter Wilson Trust 25/02/2022-PT. So that's how you would create your private trust number, which would tie in with your security agreement. Okay. Now, if you go down and have a look, the security agreement that you had before was only 2 or 3 pages. This here is immense, covering every single item of anything that you could ever hope to have inside your private trust. But this is the start of it. This document here is starting how we are going to create that. Okay, so that needs to be done. If you have already done and went into the private and you haven't got a security agreement like this one, you need to do it again, and you can do it as an amendment, right? And you don't even have to send it off to the Sinister Seven if you don't want to, because it's tying into a private trust. Hopefully that makes sense. Okay, so what I'll do is I'll stop. Right, so hopefully you should all see this. This is the notice of statement of interest. All right, an SOI, statement of interest. This is how you're expressing your trust. This is how you have to tell people that you are creating this trust. So the SOI, statement of interest. So it is the Smith & Smith Private Trust in this case. Okay, so to read it, it says this notice of statement of interest and assignment serves as evidence that trust property title number, right? So you have to create the title number for every item. Now, let's just try and, like, it's up to you how you create these title numbers. I have done private trusts with people with literally 7 children, and every single, well, I shouldn't say children, 7 sons and daughters, and every single one went in by their name and by a trust title number. So if you were going to do, for instance, and you should, all of your furniture. Now it's up to you. You can either say living room furniture comprising of 3-piece suite and whatever else, and then give all of that a title number. Or you could say chair number 1 and give it a title number. Chair number 2, give it a title number. Settee, couch, whatever you would call it, and give that a title number. So all of these have to have title numbers. Okay. So it depends on how you want to word it, how much work you want to do. The clearer that you can be, the more intricate and precise you can be, then the greater power you will have if anyone ever comes to challenge. Literally having separate items done, that will take a long time and be very painstaking to do, but in the end, it's possibly better to do it that way. Okay, so literally that's how you're expressing these items to go into the trust. All right, so where are we? It's right. So it tells you on there, right, that the what we've done, okay, and again, this is where an expense will come into it if we read it out. So you've got the property title and number, which we've just said, tracking number KB0123, blah, 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 has been transferred to the trustee's name in the Smith & Smith Private Trust with the blah, blah, blah number for the special purpose in confidence of use with the reference to the Smith & Smith Private Trust with equitable asset. If you look, it's the same. Wrote that PA, which property asset 01, it's the same as that one. Okay, held in private from the date, from the 31st of October in the year 2021. This serves public notice by the settlor as owner and holder of all rights, title, and interest with the equitable asset. Again, that's it. Let's just say that that was like your couch in your front room. Okay, right? Property title number has been transferred and assigned, okay, specifically as trust deposit to the trustee as follows. The settlor hereby confirms that the trust property is already in the possession. So they've actually put it into there. Now, obviously, whatever addresses, you make it all up, or not make it up, but you put it in your own, I should say. Okay. So what I've done is, right, it's got, when I've put it into the trust, this is the express part. Okay, very important to express it. So we are going to use recorded delivery or signed for delivery. So what I'm going to do is, like, it's up to you. You could literally do this with every single item, or I could say, look, I'm going to do this package and I'm going to put all of this package and I'm going to send it to myself. You send it to yourself, recorded delivery. That's why you get that tracking number, right? And in the recorded delivery, when it arrives, you can open it. It doesn't matter. It's not on there. And then it would actually got the date and the evidence All right, and we're going to go over and explain that again, how to do it. But then this is going to show anyone and everyone who ever asks when and how you put that into this private trust. This is actually the specific individual bits of the property. Okay, so literally from the public notice statement of interest, it breaks it down to every single item that you put into the private trust. You're doing it with recorded delivery. All right, so that's what I'm saying. You can make it as painstakingly detailed as possible, or you could put every room into one package. So right, so say you're going to do one letter, like, or one notice of here, and then you could have a list underneath, right, where it's just got, obviously I'm just talking about one item here, where I've got PA01, look at it when it says title number PA01 SASPT, which means Smith and Smith Private Trust, by the way, and the 311021 is the date, -PT Private Trust. You can create a different type of number if you want, right? So you could literally have that there and put every single item in the front room, for instance, then a different a different title number for everything in the dining room, a different one for everything in the kitchen, and a different title number for everything in bedroom 1, bedroom 2, bedroom 3. But you could hold it like that, or you could literally do it for every knife and fork that you had if you wanted to be that crazy. All right, but that is how you actually express every item into the trust. And you have to do it, you have to prove it. So to prove it, we send this notice to ourselves by Royal Mail, and it has a tracking number which shows when it was sent and when it's delivered. And then we keep it in a file. So our file will have when we've expressed the trust, when we've expressed the items into the trust, which is what this is. So you have that all in a file. So if you were ever challenged at any time in the future, then this is how you would actually prove not only did you have a trust, but this is why that item can be covered in that trust as well. All right, so this is the memorandum. Now, I don't know, hopefully that you have actually downloaded most of this already. Okay, so everything starts off like IAMAN use plain and simple English, plain and simple accounting systems, memorandum of trust. And this is just telling you a little bit about it. Okay, so IAMAN Fred Henry is a private man. Obviously, you can change all of that for how it is. Standing under law, not statutory legislation. Only state this fact to point that out, even though being in the private, it concerns me not. Statute as well as law recognizes the fact of the existence of trusts. Therefore, an expressed private trust, there, blah, 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 exists. That's Smith and Smith Private Trust, SASPT, and the number. The expressed private trust, reference number, blah, blah, has been created voluntarily and evidenced in writing by the man, Fred Henry, who sometimes acts as settlor. Very important that we use these words like that. It might not look the best in English, but it's very important how we actually create this. So Fred Henry Smith, well, I've got this limited. So I created one with a limited company, but I also created one with just the man on the legal fiction as well. Okay, so don't get too concerned. You can just do it with your legal fiction. Is the named trustee. So yours could be, forget the limited part, right? It could just be Fred Henry Smith is the named trustee in the Smith and Smith Private Trust. So your legal fiction, right? So in my case, my capitalized name, Peter Wilson, not limited, just Peter Wilson, is the named trustee. So I am the named trustee for my private trust. Okay. So everything gets held in the capital name, right? Which means that I, as the living, am not held responsible for the actual property. Okay. And the rest of it has the power and duty and respect, which are accountable to manage, employ, or dispose of the equitable assets in accordance with the terms of the trust and the special duties imposed upon them. Expressed law, the man, Fred Henry, which would be obviously the man, all right, sometimes acts as settler. So when we've actually gone through the trust document, which is the deed, then that has got all of the rules and regulations in. Okay, so this is just telling them they've got the memorandum of the trust. Okay, so this all has to be held. So when you're going through the trust document, the trust deed, which we will soon, and it tells you on there that you have to do accounting for it, it means that you have to account for every item in, which is an acquisition, and every item out. Okay, so that you do accounting. It doesn't mean that you have to have an accountant. It doesn't mean that you have to tell the HMRC about anything. That's not what it is about. It's about you taking control of your trust. So you show them what goes in and what goes out. If anything ever does go out, you can put everything into the trust. You can put, say, your sons and daughters, your but that's hopefully never going to go out. But also if it's your own home, then you put your home address in, okay? And you will have it referenced like that. So whatever goes into the account has to be accounted for, or into the trust has to be accounted for. And anything that you decided to move, say, for instance, you bought a vehicle, you want to get rid of the vehicle, get a new vehicle, then you have to show that you've an acquisition and a sale will go in, and there's different paperwork to do that as well. Okay, so it's just accounting for what goes in and what goes out. All right, so at the bottom there's just like a little bits of acts and statutes which show how the actual laws of trust are described there by that L.J. Turner and in Milroy versus LOR law. Okay. So this is just the memorandum of trust. Hopefully, like I say, like you have all downloaded most of the documents, if not all of them. Go on to the next one. And then, all right, now, so again, starts off the same. This is the public notice. Now, this is the actual certainty of intention. Okay. On here, so certainty of intention is the intention of the settler to create a trust as stated in the terms of the express trust. I don't know how to say them names. It sets out the principle where a trust was expressly declared, i.e., conscious creation of a trust. So you're telling them that you've done it. Certainty of subject matter. The subject matter is identified as equitable asset, special deposit, trust deposit, title number, blah, 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 held in private trust by the trustee, as per London Wine Company Shippers Limited, which states it is necessary for trust property to be identifiable. Certainty of objects, beneficiaries. The beneficiaries are identified as whoever it would be. It's well-established principle, blah, blah. Again, it's talking about the trust law. So this is your notice of interest, actually telling them that you've set up a private trust. Okay. I'm not going to read all of this out because it's huge, but it starts off there and it's got the strictly private and confidential express private trust, the number of it there made on that day. Okay. Now this here, as we go down, is all of the clauses, goes down all the clauses, and then it explains them. Now, it tells them what it means, like a man or a woman, okay, a difference to a person. I'm not going to go through all of these, but I will take it to the end. You can see how I've tried to cover every aspect. I've went over many different trusts for different setups. And this here is always written, all right, as a man, okay, not as a person. But it uses the words person whenever we need it to make, like i.e. for our trustee, which will be our legal fiction. So at the end, and it comes on to the actual express private trust, the deed titles, and it's showing it and explaining it here. All right, and obviously it's got the date written on, the name of the trust, and who everybody is on the trust. Okay. So you have it here. So like, for instance, a man or a woman who sometimes acts as beneficiary means the following: a man, Fred Henry, and a woman, Jenny Jane. Obviously, everything's the Smith family in our case. Okay, so it explains again, look, see, the trustees means Fred Henry Smith and Jenny Jane Smith, and they're the legal entities created by Crown Corporation as a corporation in the legal society. These are the trustees holding it for the benefit of the living. So you have, let's just call it their words, you have the dead, basically, or the dead entity at least, holding it for the living. And going through is all of the different creations, and there, so the trust created by Express Trust shall be known as, so you've given it your name. It's in red, so you can actually edit your details in. Appointment of a man, Fred Henry, who sometimes acts as settlor, so that would be there. Settlor, which creates the trust. So your address, you truly want to have your address different to where you live. You don't want it your home address, if that's at all possible. Okay, even if you have to get, like, you know, like rent, and it, I mean, I actually rent an address, if that's the right way of putting it. I pay a yearly fee so I can use that ghost mail address to put everything into. I don't want anything tied to my home. Okay, so the and it goes, oops, daisy. Okay, right down at the very bottom, and it goes into the schedule. And on the schedule here, place of settlement, that is where, I mean, that would be the address where you have your trust, dated it onto there. And the settlor, which I've got like as the man. The trustees, look, I've got this done in a limited company, but you know, my personal trust, if that's the right way of putting it, is just Peter Wilson, not limited, you know. And there's many arguments for different. So the trust settlement sum, just going to put £10. All right. So this is to start it off with. Yeah. Name of the trust. Applicable law will be, presuming most people are in England, Commonwealth of England common law. So the principals, right, which will be the owners, again, is the man and woman. Okay. The primary beneficiaries, they're the main beneficiaries, right? So that you are literally the ones that are going to take the benefit from, is going to be the lowercase man and woman. That would be like, say, you and your partner. This is the way that this is laid out. And what I've got is the default beneficiaries here. You can have secondary beneficiaries if you wanted to put that in. So that would be somebody, for instance, that would take it along with you if you wanted to do that. But if you got you and your partner, then that's not going to be used, and neither is the tertiary beneficiaries or the tertiary. But, right, this would be like, we have ours where it's going to pass on to our son. If any, when we die, then the trust gets passed on, as he would be the default beneficiary. It's defaulting because we've died. That's what that means. Okay. And in essence, okay, that would be it. There's a little bit, and this is how you would actually get it executed, i.e. putting the autographs in by the trustee and yourselves onto there. Okay, and this one, this is the trust deed. Okay. So what I'm going to do is I'm going to go back to the board, and I'm going to show you how we actually go through the creation of it via doing the newspaper and the actual putting the assets in. So what I'll do is, hang on, I'm going to stop sharing there. And just on that part there, I think Rose has a question, I think. So we'll put, ask Rose to unmute, or did you forget to put your hand down?
I just wanted to go back to what you said about the trustee and it being either the legal fiction or the limited company. I'm in the process, I've set up my limited company. I haven't got the documents back yet. I just did it yesterday. Is there any obvious benefit to using the limited company, or is it a bit more complicated than that?
Well, I'm discussing that with Darren right now, and he's like, so well, why involve like the limited, because that is the corporation again. But when I say it, your capitalized name is the corporation. So it's the same, it's identical, but it sets it up slightly differently by making that limited, because I've got a limited company, so everything's gone in the limited name and I've disappeared from many different things. But the way I see it, the trustee could be the limited company, but as long as you've, we're still arguing about it, right? Not in a bad way, but like you say, oh, it could be this, could be that, doesn't really matter. So the limited company can be used to many beneficial things. So if he's saying, and he's been doing trusts far longer than me, so if there was ever going to be like anybody that would back down, it would be me and say, don't make it limited, just say put the corporation name, which is still full capitals and is a corporation. You're just not having limited written after it.
Okay.
Yeah. So like I say, he's been doing it for 30 odd years. So if he reckons that there could be like an argument about it, then just leave it off. Which it makes no difference, because you're still going to use your legal fiction as the trustee.
Okay, thank you.
Yeah. All right, and there's another hand. Unmute. Xanthi, is that correct?
Yeah, that's right. Thanks, Peter. First thing, I haven't been able to download the docs. It says that they're unavailable, sort of page unavailable. So I don't know if you can post them in the chat. I tried earlier, and I could do all of your other ones, the SDSAR and all of that, but the trust ones I couldn't download.
Right. You should just be able to, I mean, what happens is you click on it and it sends a request to me. Give me 2 seconds. I'm just going to go and have a look.
Yeah, you would.
Send any requests.
No, it just said a computer sort of page 401 unavailable, a bit like an error.
Right. Well, that shouldn't say that.
I know. Just for the trusts ones.
No, I haven't had any requests. Well, I've had one, but not from you. All right. So then I just share it and then it gets sent straight to them. What I'll do is, hang on, I'm going to come back into the Zoom. If you send me your, in fact, I tell you what, would I be able to put it in the chat? Let me have a look and see. I'll see if I can put them all in the chat now.
Or I can send you an email.
Yeah, send me an email, because
what's your email, Peter?
Send it to gold, GOLD,
yeah,
at claimyourstrawman.com.
Okay. The other thing is, this is the first Zoom I've done. So were there others on things like the lawful law demand? What have you said? You said you do that first process. Was that a few weeks ago?
So say that again. Sorry.
Well, you were talking the first. You said before we got into the security agreement, you talked about doing the first bit. Yeah. And I'm assuming that was on another Zoom, another week. Is that correct?
Still don't understand what you mean. The lawful notice and demand is if you go into my website, okay, there's a series of documents that you have to not have to, but that you can download, which is going to put you in the private position.
Right. Okay. So
that's with the government.
Okay. So that and then I do that before this process.
You've
and
got
when I looked at and when I looked at the trust thing, is there a time scale anywhere for these things that documents we're sending out?
On the trust, no, but on the lawful notice and demand, yes.
Okay, thank you.
So when you send the lawful notice and demand out, you're literally sending it to the government under the Set of KV Act 1666. It declares or states you're dead.
Okay.
And it's still there on the government website. You can go check it out, and you have to tell them you're not dead. That's why we use the lawful notice and demand. And then you have to give them 40 days and 40 nights to rebut that, because it's in an affidavit style.
Okay.
But you can start sorting out the private trust before you've gone through the whole process, as long as you've started the process.
Started that process. Okay. But then that makes me ask, how then can the fiction be a trustee if you're going to basically rebut the dead fiction? How can that be a trustee?
You're not rebutting it. You're telling
Okay.
them you're live, so that you are a woman
Uh-huh.
and you have a person.
Right, but weren't they, if you, as you say, access the SESCV or whatever you refer to that, won't they then kind of negate the dead person? The dead person's been reclaimed, haven't they? If you do
No,
that.
you can't reclaim the dead person. They own the dead person.
Okay.
Whoever created it owns it. Now,
And they keep it then, do they? Even if you
they
do
keep
this
it
process
forever because they created it.
Okay, and they don't sort of uncreate it, as it were, if you do this process.
No, because they're still gonna use your bonds and your legal fiction to
Got you.
invest.
Okay, great.
Yeah, so they're always going to use just because you're saying we understand what you're doing doesn't mean they're going to stop doing it.
Got you.
So literally what we're doing on the lawful notice and demand, we're saying we understand, or we don't. We do not understand. We comprehend that you are a corporation and that we are not a corporation. And basically, if you read through it, I know it's a huge document, but you can never own, let's call it a straw man, okay? But you can claim like the control of it, which is why we bring in the limited company side. You can control your corporation name, but you will never own it.
Yeah, okay.
Right, so they created it, they will own it. I'm talking about your surname, whatever it would be, but it will never disappear. And they you know, at the end of the day, what they do is they use all of these names to make companies, to make like literally trillions and trillions of pounds in wealth. So they're not going to stop just because you tell them that you realize what the truth is.
Sure. Thank you.
We're going to create the private trust. So we're going to have it like in that triangle. Okay, so we're going to be at the top. This is going to be, already got that, the settlor, okay, or the creator. That's going to be, we're going to create this trust. Okay, so we had said about like the intentions, the three definites, right? So when we decide that we're going to create it, like we said, this is the pen, I'm going to give it to the trustee to look after. So we have the trustee. All right, so I'm just going to call it, I'm just going to say it's for me. Okay, so right, what we have, right, the man. Okay, Peter the man, right, and he is going to be right the settlor. I am going to create the trust. Okay, so that's me. So I'm up here. All right. Should have done it in a different color. So there. Well, I'll tell you what. Right. That's that one there. So what I'm going to do is I'm going to give the property, my property, whatever is property I am going to give it to the trustee. On the trustee, right, we're going to put the trustee in the different color. That there, the trustee will be, this is mine, okay? Full capitals, trustee. This is a legal fiction. This has been proven in courts time and time again that this is different to this. Okay? It has been proven in court, many different case laws to show that a legal fiction is not a man. All right, so it's not as if we're trying to like reinvent the wheel. We're just using what they've already done. Okay. All right, need a different color. So then we have the third one. Oh, this is a horrible pen. The beneficiary. Okay, let's get a different pen. I don't like that one at all. This one is red-ish. So the beneficiary, that is going to be the same as us because we are going to be the beneficiary of our private trust. Okay, so the beneficiary on there, right, we're going to put that over there, will be again the man. Obviously, I'm just talking about me because this is the way I've set mine up. All right, woman, whatever. Okay, so we set it up as the settler. This is how you're going to do it. Okay, and as the settler or the creator, because we're actually building it, creating it, is going to be using your lowercase name. That is you as being alive. What we're going to do is we're going to put it into the trustee. They are going to hold it in trust for us. That is going to be your legal fiction, your capitalized name. A very different identity, a different entity, and it's been proven in a court of law many times. Then the beneficiary, and it does. If you wanted to set up a trust that really for a different person, you can do that. A different, so you do all of my stuff is going to be in trust for my children. You can do that, right? But I'm just saying the way we're setting up to protect, the way that these wealthy set it up to protect themselves from us, and it is from us, right? They will set it up as to themselves as the beneficiary, and then the default beneficiary. All right. I write this in black so that you have the what is it called again? Like the creator. Okay. All right. The creator creates the trust, right? They give it to the trustee. I'm going to put that in capitals into there. Okay, so it goes to the trustee, they give it to the trustee holds it, holds the title. They hold the title, they control the title, but they never own the title. And then the trustee will pass it on to, say, the beneficiary. Let's set that. Okay, and then the beneficiary, like I said before, if it was you and then you have died, then you have like your default beneficiary, which is passed on to from there. So the creator or the settler, which will be us, we're creating this private trust and we're putting it into our capitalized name, which is the trustee. Then we're putting it down to the beneficiary. In this case, it's going to be us. But we also have a default beneficiary, which in my case is our son, which is our children. So that, you know, I'm saying that like, so you understand it, right? And that's how it goes down. Okay. This is how it's going to be set up. And this is how we protect all of our assets. And then when everybody's writing to me and saying, you know, I've got, you know, people banging on my door, it's got the bailiffs coming round, you know, there's something wrong with the mortgage. This gets rid of all of it. Okay. So many different problems that I get like calls on all the time. I'm not saying I don't want people calling and wanting help, but, you know, if this was set up correctly, as I'm trying to show you how to do it, and we will do more videos on how to do it as well. There will be more explanations. All right, set up in this way, it takes, especially on the land registry for your home. Okay, so on the land registry for your property, I don't mean property as in the building, right? So let's just say like your house. Let's obviously it's a house, right? So your house is put in at the land registry. Okay, and it'll have your name on. Okay, so when you're getting trouble or problems or anything like that, all right, with the mortgage company, if it's still got your name on the land registry, that's when they're going to get problems, right? So what we do is the land registry, that you actually can get it changed to get put into the trustee's name. and it can actually say, right, let's just say on that one, Smith and Smith Private Trust trustee. So it wouldn't, if it was my case, my name's not on anyway, right? But if it was my case for my house, and it's got Peter Wilson on, I can get that taken off. And I can get Peter Wilson Private Trust trustee written on my car. Nobody can find my car to send me a ticket or anything else, because that is the only name that is on my car. On my V5 document says trustee. Okay. And it's not at this address, it's hundreds of miles away from me. It's up to you where you put your address. Everybody can be different. You know, I've actually got a business address as well. I could have used that one. All right. But this is how it gets set up. This is how you protect yourself. And that's how the rich and famous protect themselves as well, if they're clever enough. Okay. All right. So that's how we're going to do it. So the first thing that you want to do, just on your case, right, you will do your trust deed. All right, the trust deed is the big long one, okay? And the trust deed will also have your schedule, I don't know how you say that, like American version, English version. You're going to have your schedule, okay? I think it's number 1 that's written in there, and it states on there, okay? So you create the deed. This is the deed itself. And then with the deed, okay, you're going to send this deed special delivery, okay, right, special delivery to yourself. All right, so you create the deed. This is your expression. This is you expressing your trust. This is you making sure, literally on the term it says, when you express a trust, you tell someone. So what you're doing is you're going to tell everyone. So you do it by sending a special delivery to yourself. So what you would do is on there, get the deed. Okay. With the deed, I would do it with Postal Mechanics. So what I would do on the deed, on the top of the trust deed, print it all out. You've edited it. So you've put your name in, the trust's name in, and all of that. All of the red, you've now changed to black. On the top right-hand corner, I would put the £1 stamp. Okay. Then I would take it to the post office and I would get them to stamp it with the date on. That takes the value out of the stamp in their eyes. All you got to do is say, look, it's a trust document, has to have the stamp on, put the date on so no one can steal a stamp. That's all you have to tell them. Then when it's got that date on that stamp on the top of the document, then you send that document, special recorded delivery, to yourself, right? So it arrives at home. When they do the special recorded delivery, they get a special silver sticker and it goes on the front of your envelope. The post office themselves will peel off the reference number and stick it in their postal union books. Okay, perfect proof. Then when it arrives at your home. You get it in there, it's in the brown envelope, right? You open it, you take it out, but on the front there, the silver, there's another little reference number. You peel the second reference number off, and then you put it underneath the stamp, okay? So the front page of here, you have your trust deed. So what you've done is here, you have put your stamp. Okay, that will be UK £1 stamp. Before you do anything to it, you get the post office to stamp their date on it. Once they've stamped their date on it, you at the 45-degree angle will put your autograph on it. Then you'll get your thumbprint and you'll put your thumbprint there. So it covers the left-hand side of the stamp. Okay. Then, right, what you'll do then is you'll send it off to yourself. Okay. It'll come back into the post through that special recorded delivery. You will peel off the reference number. And then you will put it here, just underneath the stamp so that you can see it. Okay. This is all proof of the expressed trust, right? So because it's private, it's not going to get sent to a solicitor or any of those government bodies. This is how you have proof. So you've got your trust deed. This is the document. You've done your postal mechanics. And then when it comes there, then you take that out and then you put it, and that will be your proof that you've always expressed. So there's no way that anyone in the world can ever argue the date and the fact that it was expressed by you, the settlor. Okay. All right. Then this is what you're going to do with the trust deed. Okay. So the trust is now expressed. All right. Then I'm just going to call this res. Okay, your property. Which when I went through the documents and I was showing you how to do the notice of interest, how to actually put the property in. Now you're going to have two other forms as well, which I will send out so that it all lines up together. Some of them just are kept just by you, which is the acquisition and the selling. Acquisition, whenever you buy something new and you want to put it in, you need to fill in a new form and you need to send it off. Okay, right? And it's just for your records. You have to keep the annual records. And anything that you decide to sell, like I said, swap the car or anything like that. But then when you're doing the property, you're going to do exactly the same thing. You're going to express the property into the trust. So if your home goes in, let's just say, like, you know, let's just go, it's got, right, I'm going to call it res number 1, 2, 3, 4, being home at, I would write the words. Let's just say 22 Smith Street. Blah, 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 blah. Okay, so that's there. That is the res number. And then you would actually say is being deposited. I've just read them out to you. Okay, into the trust, right? And it's got the name of the trust. I've showed you the documents, and you would do the same. There's your stamp. For £1, take it to the post office and get it stamped. There's the post office. It's not your date, it's the government's date. The post office is the government, the postal union. Okay. When you're doing postal mechanics on the postal union, there's only 3 countries in the whole world that can do it. Luckily for us, the UK is one of them. All right. So it's the UK can do the postal mechanics. So when you put the stamp on, you do exactly the same. Then you post it to yourself, special recorded delivery. All right. Once you get the post office to stamp it, post office stamp the date on it, you take it home, autograph, 45 degrees. All right. Thumbprint onto there. Then you send it to yourself. Your thumbprint is the seal. It can only be yours. All right, you can get a company seal, but anyone can make any company seal identical to yours. They can't do an identical thumbprint. That's why we do that. Okay, so then when you've done it and you send it, and then again, the special recorded delivery part goes onto the bottom of that stamp. So this is how we do all of our documentation. So not only do you do it to the actual trust document, but you do it to every item that you actually put into the trust. That's why I'm saying, right, rather than say I have one chair that I've put in and I have two chairs that I've put in, and you do a different document for every chair. You could say like living room furniture, one document, dining room furniture, one document, all of the bedroom furniture, one document, if you see what I mean. Or you could be completely anal and even put in every single, I have a pen, I have a fork, I have a spoon, and do that. But it's going to be expensive and and long-winded. That's all I'm saying. So, but this is how we actually express property into the trust, and you express the trust deed using the government, their stamps, their dates, the Universal Postal Union and the postal mechanics becomes completely provable that you did it. That is expressed, right? And nobody could ever argue with that. And that's how you actually get it ready to be defended if it was ever challenged at any time with from the legal society or anything like that. Okay, so that is how you would actually express it and put your items into the trust as well. Hopefully I haven't been too scribbly, all right? But does that make sense? Does anybody got any questions? You can click your button to lift your hands up or whatever it is there now, if you let me know, okay? And the ones that we didn't have that I've got somewhere on there and I couldn't show them are the acquisition, which means when you buy, it's very easy, it's very plain and boring, but it just has to be along with all of the other documentation, which we're going to make sure is going in the full package for everybody. So on the membership side, I'll click the buttons in a second. On the membership side, like that's why it can't be downloaded so easily. I don't know what anybody that can't download it, send an email to me, gold, GOLD at claimyourstrawman.com if you're not able to download the documents. And what I'll do is I'll send you either the document out of my own file or a link. I'll send you both just in case to make sure that you can download one or the other and get access to it. Okay. All right. So let's go to what's it? Rose, I think it is there. Yeah. Okay. Unmute. There we go.
So the trust deed, you do the special delivery with the thumbprint on the £1 stamp and all of that. And then are you saying that with the res, which is the list of property for each room in the house and the list of your house, your car, each page also needs a stamp and a special delivery sticker? Right.
So the trust deed itself, when we showed you the trust deed and when it had all of the clauses and everything written on like that, that doesn't have a list of your property, just has a list of you and who's who. That is that one that gets sent off. Then, right, completely separate documents would be, like you said, so it is individual. That's what I'm saying. It's up to you how crazy you want to go with it. So you could literally make one document, right? This is for the living room and do that process. This is for the dining room, do that process. Or you could go, this is table 1, table 2, chair 1, chair 2. This is the fork. But it's going to get expensive and crazy. I don't think there's anybody that's going to be so off their lid that, you know, they're going to argue with you. If you got, just say, for instance, the scenario I'm looking at, and I'm using somebody very specific, a guy called David Ward. If you haven't heard from him, check him out and check out his affidavits. Now he got bailiffs. He was fighting all the time, doing what we're doing. He was fighting all the time. And the bailiffs one day, and they come to his house, and he had a big pile of there were videos. VHS, remember VHS? And he had a load of VHS, and they actually were checking the VHS so that they could sell them. This is the bailiff in his property. Okay. Now, if you just put, like, you know, all of these properties were all under trust, you wouldn't have to itemize every single VHS recorder or DVD as we do nowadays. All right. So if he'd have had a private trust set up, they would not have been allowed to go into his house. So you could have had it there instead of saying DVD 1, DVD to whatever names were on there, you could have literally just said all property inside the living room, boom, and done that one stamp. Does that make sense?
Yes, thank you.
Yeah.
So there would be a different page for each room, stamped and stickered.
Yeah.
And then how would you do houses and cars on that list?
Exactly the same.
One per page.
Yeah.
Okay.
Yeah. But when you're doing that as well, right, you can, like I say, go further and actually change. I can't remember. I've just done it about 2 years ago, changed the name on the land registry to the trust. And there's a special form. I can't remember the name of the form, but if you go onto the land registry, or actually when I did mine, I actually spoke to them because it's at Durham, so they got the same accent as me. But so when I rang them, very, very friendly, and they went, "Oh, what you need this, fill it in, send it to us," you know, and they tell me exactly how to do it. And you change the name to the trustee. And that is like, it's like wearing a suit of armor. Honestly, it truly is. If you're dealing with your property and you don't want hassle from bailiffs or any of that, you know. And it, you know, let's just say, for instance, you're dealing with like your utility bills, and I know everyone's doing things different, but or like whatever it is that you're trying to achieve, right? It does put a huge wall up against them type of people. Okay.
Thank you.
All right. So let's go to Ash. Ask to unmute.
Hi. Hi, Peter.
Hiya, you all right?
Yeah, I'm all right, love. I just wanted to check the signature in the corner. Is that in red ink? So we do in
Well,
red
I was doing.
and red ink.
I don't know if Jez is on here today. Like, we've been doing blue ink for a while now.
Blue.
The reason why we've been doing it in blue. Now, when I send out all of my challenge notices to debt collectors or anything like that, or banking or financial institutions, I do it in blue because it's alive. It's the living man or woman.
Yes.
So we're autographing and thumbprinting, sealing. That's just a seal, like a company seal, but that's our company in blue. I've heard it before, but I experienced it firsthand in January when I went to court to help someone in court, and they had sealed it in red. Honestly, we spent an hour. It was a barrister. It was actually a barrister trying to make a huge deal out about, like, oh, this is a biohazard. You're trying to say this is blood, and we're like, yeah. And it went on. It was actually getting ridiculously boring. And they were trying to make, I don't know what they were trying to do. The judge even said, look, we have to move on. But anyway, I have heard it before from other people saying, don't do it in red, because they can try and be funny about it, saying, are you trying to say it's blood, or is it really blood? Is it a biohazard? We need, you know, I don't know. It was ridiculous. So do it in blue, and then you're not going to get this ridiculous hassle or backlash.
Okay, thanks for that.
No worries. So that's why we do it in blue. So again, what I'm going to do, because I can't do it here, it would be too boring to go through paperwork. I'm going to do a step-by-step guide on paperwork. So you literally, there's going to be there, you download it and make sure, tick that one, I've done that one, tick that one, I've done that one, I've done my deed, I've done this, I've literally all the way down. All right. So it would be virtually impossible to, even I couldn't make a mistake. All right. So, and this is all available on there. I just need the acquisition form, which is literally, I'll click a button and it'll be up there. And all of the members' web emails, you must have got one to be on here tonight anyway, right? I'll make sure I put the documents into everybody, just in case that anyone has had any problems in downloading. And also, like I said, I'll put the step-by-step guide in and everything else for you as well. Okay. And if there is any other, like, further questions, one-to-one questions, private questions, you can always send it to me at gold@claimyourstrawman.com. Okay. That's where we'll send them, gold. And because I see them and I try and clear that at least every 2 days. It's not always possible because I do have a lot of calls, but I try and clear that at least every 2 days. All right. Okay. Could it work for a condo? It can work for anything. I tell you, this is one of the most, I'm still in the middle of courses on trusts now, and I have weekly lives on trusts. So again, all of the reference books that I've said, right, Wayne, your interest in a property is just as powerful as you owning the property. So let me explain that. Let's just say, for instance, that you are renting a house or a flat or a condo. Now, the interest in the property means, first of all, number one, you live in it. That's your interest. Okay. Now, you've decorated it, right? You've done the TLC to it. All right. You've maintained anything outside to it. You've looked after it. That is your interest in a property. You can put your interest in a property into a private trust. Okay. So if you've put your interest in a property into a private trust, it would be virtually impossible through a court to get you out of that property. Say, for instance, you were renting it and you never paid rent. Okay. So it would definitely work for anything like a condo. So in reality, and I know this through reading case law, I've seen, and one of the biggest reasons why I started to do these videos was because of watching the horrendous like YouTube videos of people being ejected by the police from their own homes because, you know, and it's supposed to be a civil case. All right. But police were dragging them out so that the banks could sell their houses. Okay. If they'd have had just their interest in a private trust, right, plus the equity, right? So if you owe £100,000 mortgage, right, but you know, we've got equity in it of 10,000, only 10,000, right, or even 3 or 4, doesn't matter. But you've got your interest in it, that you've maintained it, you've like paid for everything, you paid the bills, you know, you've actually, you know, painted the building, and you know, that is interest. They could never, ever, ever get you out of that property. That's case law fact. Okay. So it could definitely do it for a condo or a flat or any apartment, even if it's in you've got a, not that I would ever recommend this, but if you have it in leasehold, right? So people have got leasehold apartments, flats, that type of thing, it can still cover it. You know, like I say, not that I'm telling you not to pay rent, but even if you're just a tenant in a property, you can put your interest, which is your love of the property, you're living in the property, you're being part of the property, you're literally your spirit. I am not kidding. There's case law on it that would never get you out.
I'm just curious, even though I'm not going against what you're saying, I just wonder, how does that keep us in honour then? You know, if you're renting off someone and
I'm not saying that you're in honour.
No. Okay. It's just because I think I'm sort of working about being in honour, and I don't care about big corporations, but you know, if you were renting off someone privately, that would be unkind if they tried to get that going. So I was more checking about, yeah.
Oh yeah, no, I mean,
staying in honour, isn't it? About
yeah, definitely. I'm not saying that it's in honour, but like once you've actually set it up in private trust, you know, that I'm just explaining that. No, I'm not certainly not recommending it.
You're not encouraging it, okay?
Exactly. You know, because that certainly is unconscionable. You know, that is not going with equity, is it? But no. Unfortunately, equity is very black and white as well. And if it's in a private trust and you've declared that in a private trust and it is expressed, then it has to stand up in equity in law as well. So, you know, I'm not saying that you should do that. But what I'm saying is, so many people, if they had known a little bit about equity law, would not have been evicted from their homes.
No, I think that's disgusting that they've been evicted. I am sort of conscious that my son rents out a property, and I'm just thinking he's worked all his life to try and get that extra income. It would be awful if people who rent it for him, although they're very good, would do something like that. I just don't feel that's very honourable. Although I suppose I'd have a different view if it was the council. I wouldn't give a shit about them.
Yeah.
You know what I mean? So,
What does that say there? Do all post office stamp on a paper? Well, you know, if you go to a post office and they won't actually stamp the date, all you're asking, when I go to the post office and I have these documents, I'm just asking, someone's asked a question, do all post office stamp on the paper? All I say is like, look, I have to put these documents in. Last time I did it, somebody peeled my stamp off and used it for a postage. I don't want them to steal it. So can you just stamp it? And if they won't do it, go to a different post office. You're not asking anybody to, they've got to be pretty anal if they won't do it. And I know there's anal people there, right? So if that is the case, go to a different post office and just get them. Someone else will do it, you know. And at the end of the day, if you know, you've got 3 post offices and they all speak to each other, they're all best friends and none of them will do it, then you can stamp the date on yourself. Okay, because as long as it's got the date on and then you post it to yourself the way that I've done it, this is literally belt and braces. All right, you've got a belt by getting the postage stamp date on, but you've got the braces as well because you've actually sent it to yourself recorded delivery. They can't say that it wasn't recorded delivery and it's a post office date, it's a post office stamp, it's a post office like slip that you've took off. Okay, it's applicable to any country, anywhere in the world. Yeah.
Hi, Peter. I was trying to unmute myself there, but I realised the door was locked. Yeah, just regarding the postal mechanics, I've been doing it. I've been signing compound fact name across the stamp and then putting the seal on, then getting the stamp at the post office.
Right. Well, I mean, if they can do that, they can certainly do it. Just if it's got a stamp on its own, then can't they?
Oh, she's on board with what I'm doing. I've explained little bits to her about, and she's well up for it. So
yeah, no, that's great. That's great. You know, I mean, you know, you know, it's not like you're doing anything wrong or doing anything like, you know, like weird or wonderful. You know, let's just say on their world, illegal. You just want them to stop. You're taking the jurisdiction off the stamp and putting it on the land, so you're getting that stamp to stop anyone else using it anyway. So nothing stupid about that.
No, she's she's very interested every time I go in with something. So yeah, very good. Right,
brilliant. All right, thank you. So Wayne's just asked there to be clear, we create the trust and send it only to ourselves. It is true. You only have to send it to yourself because you're using the postal mechanics as the proof that it was there. So you're only going to show it to anyone else. It's a private trust, remember? Okay, so you're not going to tell anyone else anything about it because it's private. But if you're challenged on it and you have it created with all those dates, then there is the proof that it was created when you've said it was created, and all of the items are in the trust when you said they were in the trust. All right, does that make sense? You know, so you don't have to send it to anyone else. You know, if you did, you could send it, but there wouldn't be any benefit to it. You know, if you're going to send it to, say, the Sinister Seven, like we did with the, you know, the lawful notice and demand and all them documents, because you only want to prove that you created it, and it's a private trust. It's in there on them dates using the postal mechanics, and it's irrefutable, really. Nobody could say it didn't happen. It's using the postal union. It's using there, and that's powerful. Okay, so, but thank you very much for coming along, and I hope you enjoyed it. I hope you got something from it. Any further questions or anything, send them to the gold email. This is recorded and it will be going up once it's done. All the takes ages to actually, I don't know what they call it, render it and change it, and then I'll send it up into the website. All right, brilliant. Okay, thank you very much. Thank you for coming, your time with me. Take care. Have a great weekend. All right, and see you all again very, very soon. Take care, people.